Thank you for joining us on Black Investments Matter. I'm Antoine Anderson, and we're going to probably find out within a day or two, or tomorrow even, how this is going to break down with the future of this trial in jeopardy. Of course, I'm talking about the Donald Trump trial, but in recent weeks, it just seems like this is all about the Nathan Wade and Fani Willis trial, as if they are being criminally indicted. Which is the furthest thing from the truth. But there's something that's just been gnawing at me from the beginning of this motion, and that is, how did an attorney from a Georgia elections interference case get privy information about a private divorce that was sealed? Let's talk about the timeline of how this thing breaks down.
The seal in this case. It's our understanding from emails with counsel that this Mrs. Wade's lawyers do not object to that seal order being lifted. I believe Mr. Wade's lawyers do.
I find that the prior order, although it was by consent of parties, was not properly entered because the Uniform Superior Court rules require a hearing to be had. We can find no evidence that any such hearing was ever had, so I'm going to grant the motion vacating the consent order sealing the record. And I'll do that today. I'll have your written order, Ms. Merchant. Unless you have something else, you're excused.
I do not need so much, Judge.
Yes. Well done, counsel.
Now, y'all caught that from the judge, right? Well done, right? We're going to get back to that. Well, maybe not. You know what it is. However, but I want you to focus on the timeline of events. What you just saw happened on January 22nd, 2024. That motion and the order granted to unseal Nathan Wade's divorce proceedings. It was sealed before that. Sealed up until January 22nd, 2024. But let's go back. It doesn't matter what year they were referring to in that exchange between Merchant and Terrence Bradley, when they contradicted themselves or each other over the timing of some text that went back when Miss Merchant said that she had found out that Nathan had paid for some trips for Fani.
On January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with a business card. You told me you were on a plane home from Dubai, that you would call me as soon as you got home. Do you remember that?
Okay. She said January 5th. Are you discussing with Terrence Bradley what happened in a divorce proceeding that was at that point in time sealed? Why is this a question? Well, if you look at this document, up until September 30th of 2022, Terrence Bradley was representing Nathan Wade in his divorce. See, this is where it gets super, super messy. And if you are following where this evidence is taking you, you understand that these two lawyers was gossiping. Somebody got the cow by the tail and went forward with some allegations and backdoored this seal. Even though on the 22nd it was unsealed, there was so much more information that come out afterward, a flurry of motions, not pertaining to the divorce, but where this money went. Because that's how that judge in that divorce hearing to unseal the motion was leaning. He didn't care about who was sleeping with who. He wanted to know where that money was at. And now we found out what they were going after. They're going over specific invoices, specific records. And in none of those records did they find any mention of any direct payments from any of those sources, not the Amex, not the Synovus, not the H2O, not the Airbnb, anything that benefited anybody other than Nathan Wade. Interesting stuff.
Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Waite accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay, but regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him.
Sure. And his previous testimony was that was totally covered by privilege.
Yes, he lied.
Now, it wasn't bad enough that Ashley Merchant, the person who called Terrence Bradley to the stand, said that he perjured himself. Then you had the DA come out and say the exact same thing on another area of testimony as to why it was that Terrence Bradley was separated from the firm in the first place, asserting that attorney-client privilege throughout, and then once challenged by the DA, his attorney does an about face and like, hey, maybe we do need to talk about this not being privileged communications. It's a mess. And it's all started over what was going on in this man's divorce, this Nathan Way's divorce. So at the very least, as a spectator, again, we're not legal advisors here, but as a spectator, this does rise to the level of a distraction. And I think in terms of the case and what this special prosecutor is actually bringing to the case, I don't know what's going on behind the scenes as far as what's going on with his work ethic, but this is so much of a distraction that some of the work is not being done, or you're at least making more work for your staff. That would be grounds enough to recuse yourself, fall on a sword, and let this case go through, which satisfies what the defense was going after anyway. Anything they can do to slow down this case. Whether they get a slam dunk and have the entire case thrown out, I don't think that's going to happen. Or if they severely cripple it by getting rid of the lead prosecutor. We already heard what happened when DA Willis tried to solicit special prosecutors like former Governor Barnes to prosecute. And he told her flat out, I do not want to live with bodyguards for the rest of my life. That is real down here. So I think that in itself will be grounds. Anything short in this judge's ruling of dismissal of Fani Willis is going to be a victory for the DA. If the DA is still in this case, they win, because now the gloves come completely off. Whether Wade stays or no, that's up for debate. I don't think he does, but anything short of the Fulton County District Attorney's Office being pulled off of this case is going to be a win for the Fulton County DA's office. And then fireworks are going to start to fly. Let me know what you think at the end of in the comment section down there. Love to hear from you. Keep it clean, keep it respectful, keep it intellectual. Thank you for watching. Hit that like and subscribe button. Thank you.